That's not a mandatory requirement. It could be a handwritten will, and you could have two people who are not the legal heirs, preferably, sign this document. So, writing a will, it's pretty simple. It's the Indian Succession Act that defines what a will is. So, where a testator wants to have a document which clearly outlines, what of his assets would devolve upon the legal heirs. This is something legal heirs, or even otherwise. Will is the best option. So, what is the legal requirement for a will? It need not be registered. There is no stamp duty that has to be put. The only thing is that the person who's writing a will should be of sound mind when he's writing the will, and the will, once it is documented, it should be witnessed by two adults. In terms of the execution, and that's all that is required. And of course, subsequently, you can have conducers which can also amend the will. So it's not like once you've written a will, you cannot change it. It can definitely be changed, and as long as it is very clearly mentioned that this is the last will and overrides all the other earlier wills that have been executed by you.
So I just have a follow-up question to that. So does it mean that I can write my will without a presence of a lawyer, or does this need to be registered? If I have written a will, is it a handwritten will is okay, or does it need to
Absolutely.
be registered?
Absolutely. As a matter of fact, the law does not require you to register. There are provisions, as a additional safeguard, you can go to the sub-registrar's office and have it registered and have the witnesses sign the records of the sub-registry. But that's not a mandatory requirement. It could be a handwritten will, and you could have two people who are not the legal heirs, preferably, sign this document as witness to the execution, and you're good to go.